Hello, can you hear me?
Yes, what's your name, sir?
Yes, I'm here to make a special appearance.
What's your name, sir? Can you tell me your name?
Uh, Don Line.
Okay, we're on 2508, scene 2346, State v. Don Lyons, who is here today via Zoom, states again present. See, advised at your initial hearing, you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have two options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those two options would you like today, sir?
I would need request a continuance to work on my defense.
Any objection? I say no objection. Right. Looking to age the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, just we'll see you back here on that date and time.
Say it again. You said
December
January,
22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346. State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge. And it's for count 3 operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500 hundredths of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. You understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yes, that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today. But what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What's that date? Whoa. No, I'm mistaken.
Okay, we're gonna do the 28th.
Yeah, 28th.
Okay, we'll say January 28th at 10 a.m.
Yes, sir.
All right, so we'll see you back here on the date and time, sir.
All right, thank you.
Thank you. All right, Mr. Lyons, can you hear me?
Yes, I hear you now.
Okay, we can get your face on camera there.
That's what I'm trying to do.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference. Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit. No, I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
doesn't make any specific It's a request for dismissal of charges, and this does not comply with criminal rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial, April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
1:30 p.m., sir.
All right, thank you.
Okay, and that's all for today.
We're making a special appearance.
Hold on, I'm going to call the case. It says 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President Deputy Prosecutor Tyler Trulock. Set today for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Mr. Lyons, say you wanted to note something before we begin?
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay,
that was said that they had a warrant for to take my body fluids, but I don't recall seeing that warrant.
okay. Well, the time for challenging any of the procedural issues or evidentiary issues has come and gone. Today we're set for a trial on the facts of matter. So if you want issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. You what side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side,
So alcohol on the passenger side and on the driver's side.
but she was on the passenger side first, right, when you said it, correct?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. I got him supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file?
So you have to ask questions about it. It's
So
not.
you don't know if it's on file or not.
They have all my body camera, dash camera,
You don't know.
all that. I sent it to them, so I would assume so.
You said the warrant was signed around 6/21.
Well, it was around 6/21, so I've read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
Go about it like that. But I don't recall no more.
Well,
I
sure
would
to say that.
feel
You have any
I was- I
questions?
feel like I was on I do, but not right, not at the moment.
Anything up that state?
No, Your Honor.
You can sit down, sir.
Ms. Dominguez, is there anything else you'd like the court to know at this point?
No.
Thank you, ma'am.
Mr. Lyons, do you have any questions for this witness?
Yes. I know it's a
a while ago, but you know around the time that they took my blood.
I don't remember.
That's all I had.
Anything else that's it?
No,
You can step down, ma'am.
Okay,
Mr. Newtown, is there anything else you'd like the court to know at this point?
do not believe so.
Thank you.
Do you have any questions, Mr. Lyons?
No, sir.
You can step down, ma'am. Mr. Lyons, do you have any evidence to present?
And y'all didn't give me the motion of discovery. I was thinking y'all was gonna send it to me. I didn't know I had to buy for it. That's my ignorance. I don't have no evidence. No, sir.
So today's trial, the state needed to carry their burden, need to prove beyond a reasonable doubt. On count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
I mean, my grad got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. What they were present, I just gotta be nice.
Any on sentencing state?
Just a few questions, Your Honor. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at the Penn Station right now, Earth Point.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working 2 at first.
And where do you live?
Well,
Okay. Louisville, Kentucky.
yes, sir.
Mr. Lyons, do you have any criminal history of any kind?
Yeah, look right. Like the criminal history.
Yes.
I got a little record. Mainly tried. Yeah, but
So what have you been convicted of criminally?
that's some marijuana. Some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Was that the only thing you've been convicted of?
I can think of right now.
No previous operating while intoxicated convictions, anything like
No,
that?
it's my first time. The first time.
Thank you, sir.
What's any other evidence from the state?
No.
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspensions for the state of Indiana.
Yes,
Alright.
so I'm not sure how that transfers to Kentucky. That's gonna be the order for today. It's gonna be remanded in
Oh.
custody.
Alright, so what about, man, oh my granny though? But she can't really see like that, like, I gotta help her get her, you know?
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah,
And so
well, I was.
plans you've
right,
made,
you're right.
plans you've
It's on
made
me. Right.
are on you. So that's gonna be the order for today.
I'll get out and go there.
And I will notify you, you have 30 days to file a notice of appeal if you want to appeal this decision.